Welcome to This Explainer. Today, we're unpacking a really fascinating and, frankly, highly consequential legal battle that's currently playing out right now in Kenya's High Court. We're looking at Constitutional Petition E490 of 2026. And wow, this case literally strikes at the very heart of how the law interacts with human development. It's forcing a massive reevaluation of statutory protections versus our constitutional freedoms. So, let's just dive right into this by asking a pretty profound question, one that sits at the very center of this whole petition. Think about it. Can a legal framework, one that's specifically designed with the absolute noble intention of safeguarding minors from exploitation, actually end up inadvertently violating the fundamental rights of those very same youth? It's a heavy question, right? To unpack this impartially, we'll quickly move through our agenda. First, the constitutional dilemma, then the petitioner's stories, the case against criminalization, the state's defense, the healthcare ripple effect, and finally, the core legal questions the court has to answer. All right, starting with part one, the constitutional dilemma, protection versus autonomy. Let's establish the core legal tension here regarding specific sections of Kenya's Sexual Offenses Act of 2006, namely Sections 8, 9, 11, and 43.
Here's the clash we're looking at. On one hand, you have the state's absolute, non-negotiable obligation to protect children from sexual predators and premature sexual activity. That's a given. But weighed against that, on the other hand, is the argument from the petitioners. They're saying that criminalizing consensual, non-coercive adolescent relationships actually violates core constitutional rights, things like dignity and privacy.
Now, to really understand this debate, we have to define the primary charge at the center of the storm: defilement. Under Section 43(4)(f) of the Act, the law basically operates on a blanket presumption. It assumes that anyone under 18 completely lacks the legal capacity to consent to sexual conduct, period. And the petitioners are arguing that applying this so rigidly, totally regardless of context, maturity, or the evolving capacities of pure adolescence, well, that's exactly where the constitutional breach happens. Moving to part two, the petitioners' stories, the human element behind the petition. To ground all these abstract legal theories in reality, we really need to look at the real-world catalysts for this case. I'm talking about the actual teenagers involved, who brought this forward alongside the Network for Adolescent and Youth of Africa. So how does this law operate in real life? Let's look at the timeline of the first petitioner, HSO. He was 17, and he was cohabiting with a 16-year-old girl named CNK. They were arrested without a warrant in Dagoretti. HSO ended up being detained simply because he couldn't scrape together the 50,000 shillings for bail. It was only after a court-ordered age assessment proved he was also a minor that the prosecution dropped the charges. But as the petitioners argue, by that point, the trauma of the arrest and being locked up, that had already happened. Then we have the third petitioner, Tia. Now, she wasn't formally charged, but she was treated as a prosecution witness against her partner, AMO. And the petition outlines that this exposure subjected her to intense psychological distress, police interrogation without any legal representation, and a massive disruption to her schooling. It really highlights these severe social and emotional costs these kids face when they get pulled into the criminal justice system. This brings us to part three, the case against criminalization, mapping rights and autonomy. Let's dig into the specific legal arguments the petitioners and interested parties, like the Katiba Institute, are actually making against these arrests. What's super fascinating here is how the petitioners mapped their lived experiences directly to specific articles of the 2010 Constitution. They argue that under Article 28, labeling teenagers as criminal offenders for consensual acts actively degrades their dignity. Then, under Article 31, they say decisional autonomy when it comes to intimacy is a core privacy protection. And crucially, regarding Article 53, they assert that dragging minors through the criminal justice system completely violates the best interests of the child principle. Essentially, they're saying it replaces rehabilitation with totally avoidable trauma. Next up, Part 4, the state's defense, protection, duty, and due process. Now, the state, represented by the Director of Public Prosecutions, the Attorney General, and the police, they don't just roll over. They mount a very robust defense based on their absolute mandate to protect the vulnerable. Building their case, the state firmly argues that the Sexual Offenses Act enjoys a presumption of constitutionality. It's designed to protect kids who simply lack the emotional and psychological maturity to consent. Furthermore, the police emphasize they acted lawfully and in totally good faith. Take HSO and AMO, for instance. Those youths initially represented themselves as adults, and the state points out that once their true ages were verified, the prosecution followed the rules perfectly and withdrew the charges. The state also leans heavily on a legal doctrine called res judicata. Basically, that means a matter has already been judged and conclusively settled. They argue these exact constitutional questions were already litigated and settled way back in a 2014 High Court case. Because of that, the state says this new petition is just an impermissible attempt to reopen a closed book. Let's look at Part 5, the healthcare ripple effect, a chilling reality. The scope of this legal battle gets a lot wider when we introduce a compelling third-party perspective. Enter the Reproductive Health Network Kenya, or RHNK, who brings some really striking public health data straight into the courtroom. RNHK points out what they call a systemic chilling effect caused by these laws. They cite empirical research showing that healthcare workers are literally paralyzed by legal ambiguity. These workers often hesitate or even outright refuse to provide vital reproductive care and contraceptives to teenagers. Why? Because they're terrified they might face criminal liability for facilitating a crime under the Sexual Offenses Act. And the data highlights a massive, massive urgency here. Adolescent pregnancy rates in Kenya jump from just over 3% among 15-year-olds to nearly 40% among 19-year-olds. 40%. That shows an immense need for healthcare. But as the interested parties argue, the current law just builds a massive wall of fear between adolescents and the healthcare providers trying to help them. By driving adolescent sexuality underground, these groups argue the state's legal framework is actually creating structural barriers to healthcare, which they contend is a direct violation of Article 43 of the Constitution, the right to health. It's a huge contradiction. You've got the state pushing progressive national adolescent health policies on one hand, but keeping criminal provisions that scare teenagers away from those exact services on the other. Which brings us to our final section, Part 6, the core legal questions, what the court must decide. After weighing all these profound arguments from the petitioners, the state, and the healthcare advocates, we arrive at the ultimate resolution the High Court has to provide. The court is facing some truly massive questions here. They have to decide not just the fate of the specific arrests and detentions of HSO and AMO, but something much bigger. They have to determine whether the blanket presumption of the Sexual Offenses Act itself is unconstitutional when it's applied to consensual, peer-to-peer relationships between adolescents. Furthermore, the judges have to navigate the really delicate doctrine of the separation of powers. The state is arguing that changing age of consent laws is strictly a policy choice for Parliament, not something for the judiciary to meddle in. Meanwhile, groups like the Katiba Institute push right back, saying no, constitutional supremacy gives the court the clear mandate to strike down any legislation that violates the Bill of Rights. As we await this landmark judgment, I want to leave you with a final, provocative thought to chew on. How exactly should our society handle the complex, messy realities of youth development? How do we strike that perfect balance between a teenager's evolving autonomy and their need for healthcare, with the state's absolute, non-negotiable duty to protect children from exploitation? It's an incredible legal tightrope, and the High Court's decision is going to have ripple effects for generations to come. Thanks for joining me on this Explainer. I'll see you next time.